Fani Willis loses another one. Her record is now 0-4. 0 convictions, 0 guilty judgments, and 4 people who are going to have their cases ultimately dismissed so long as they comply with probation and the other terms. Now, this is what we can call traffic school plea deals. Just like when you get a speeding ticket, you sign up for the class, you admit you did something wrong, you take the class, everything goes away, right? You've got no conviction at all. In fact, this is even more beneficial than those because these will be totally sealed, and by the judge's own order, we can say legally that the defendants have been totally exonerated under the law. Now, we're going to go through this. We've gone through 2 other change of plea proceedings, and today we're going to go through a third one. This one is Jenna Ellis, and as we've been exploring these in turn, we've already covered Kenneth Chesebro, and we've also covered Sidney Powell's. We've been sort of playing the game from afar, watching these court proceedings and trying to speculate on what the documents look like that the judge is signing. And now we have the actual documents, okay? The judge has released them, and it is 100%, in my opinion, a deferred adjudication agreement, okay? It's even more beneficial for these defendants than you even thought. And so it's going to result for all 4 of them, as long as they comply, in nothing, total exoneration. And so we're going to go through it today in detail and refresh our recollection on what the code looks like before we attend to the actual change of plea proceeding with Jenna Ellis, so we can see exactly how all of this works. But let's start by going through the actual deferred adjudication document that came out from Sidney Powell. So we're going to see what Jenna Ellis goes through, but this is the form that is ultimately going to be released when her case gets there, okay? After it hits the court docket, we'll see something very similar to this. But I want to explain why this means that Sidney Powell's case is going to be going away and why Jenna Ellis's is very similar. And this is what the judge entered behind the scenes, okay? This got entered a couple days after Sidney Powell's plea deal was accepted. This is the final disposition, and if you take a look at this closely, it's OCGA 428-60. This is the first offender conditional discharge deal. It is a plea deal that is going to result in a deferment of the guilty plea, meaning they are not going to enter the guilty plea as judgment in this case, and as long as everything's completed, it will result in a dismissal. I'll show you exactly what it means and how this works. See, each one of these is a disposition. You could have a disposition of guilty or not guilty. Could have an Alford plea, right? A no contest plea. But they have the disposition of this case not as a guilty plea, okay? You don't see guilt anywhere. That is the conclusion of the case. It is an option, but it's not applied here. Instead, they have this separate carve-out where you go into this suspended prosecution mode. They take your guilty plea and they just hold it, okay? They just put it on an audio recording. They take all the paperwork. They just put it on a bookshelf and they wait. And they put you in this first offender status. So Fani has not secured for this case a guilty plea at all. The disposition status of this case is first offender status. And it's for all 6 counts, as you can see, went through a guilty plea proceeding for, but has not been adjudicated guilty for. And I know this is very nuanced, but we're going to get there. You see, this was signed off on in the case of Sidney Powell, entered 10/20 into the court in Fulton County Superior Court. And here's what the judge wrote on here. And this is Judge McAfee signing this, so you can see his signature right down here. Entered into the record on the 19th day of October, 2023. And this is for Sidney Powell, arguably the mastermind, the person with the kraken, the person who was one of the most outspoken people that we saw. This is her sentence. It's called deferred adjudication. That is the disposition. First offender deferred adjudication. They say the defendant is sentenced under first offender for these offenses, all 6 of them. This is the same pattern that we're going to see for Ellis and Chesebro and Scott Hall. The court sentences the defendant to confinement in an institution as computed by law. But that institution, right, it can be like the Department of Probation. So it doesn't mean you're going into confinement. You're just now under the jurisdiction of the probation department. Here's the sentence summary. Sidney is sentenced for 72 months to be served on probation. Now, they tell us that the above sentence may be served on probation, provided that they shall comply with the terms of the condition here. And we know what these are because we listened to the whole plea agreement. Don't break the law. All right, gonna do that anyways. Avoid injurious and vicious habits. Avoid places of disreputable harm. Report to the probation officer. Work a job. Don't change your place of abode without notifying us. Support your legal dependents. It's like all good behavior. Make restitution as ordered by the court and complete evaluations when ordered by probation. The court also orders a fine. We know these fines, $2,700 in restitution, apology apology letter, testify truthfully, which she was already going to do, and shall have no communication with co-defendants. And she must do a full recorded proffer with the state and give any documents absent the lawful privileges prior to entering the plea, which is fine. She gave them a bunch of stuff. That's no problem because they didn't break the law. But here is the big paragraph. Now listen to this. This is going to apply to Ellis, and this is going to apply to everybody that we've covered here. First offender or conditional discharge, and this is for Sidney Powell, says the defendant, Sidney, consenting here too, agreeing with this, it is the judgment of the court that no judgment of guilt be imposed at this time. So Fani's guilty pleas are not even really guilty plea judgments, okay? They're guilty pleas that are just held in this state of abeyance, this suspended state. They're just going to be closed and put on a bookshelf. So no judgment of guilt be imposed at this time, but that further proceedings are deferred. It's a deferred adjudication. So everything is suspended, and that Sidney is hereby sentenced to confinement, which is going to be with the state, which is going to be probation, as computed above, 6 years. Now, upon violation of probation terms, so if she commits another crime, or if they determine that she was a felon, they didn't tell her about, the court about, then the court can take that guilty plea and just enter it, okay? At that point, if they fail, then they may enter an adjudication of guilt at that point and proceed to a sentence. But that has not happened yet. But upon fulfillment of the terms of this sentence, or upon release of the defendant by the court, so the court can terminate this early, the defendant, Sidney Powell, and this same language is going to apply for the defendant, Chesebro, the defendant, Hall, the defendant that we're covering today, which is Jenna Ellis. Oh my gosh, my brain just dumped right there. All of them, Jenna Ellis, Sidney Powell, Scott Hall, and Chesebro, shall stand discharged of the said offense without court adjudication of guilt, no adjudication of guilt, and shall be completely exonerated of guilt of the said offense charged. Oh man, they hate that. Fani hates that. Did you hear that? Shall be completely exonerated of guilt of the said offense charged. Oh man, that's terrible. If I was a prosecutor and I got 4 of these so-called insurrectionists who led the biggest attack on American democracy since the Civil War, blah, 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 if I got all dressed up for a press conference out there, put on a suit and tie and everything, and the 4 case dispos that I have are all first offender acts that result in no jail time, no judgment of guilt, no criminal conviction. The cases are going to be sealed, and they're going to be considered under Georgia law literally completely exonerated of guilt of the said offense charged. What? This was signed off on by the judge, Scott McAfee. I've read the terms of the plea, and of course, all entered. Now, Sidney Powell got this term. This was filed on the Georgia docket. This is the First Offender Act, okay? And this is the same thing that we were speculating that it was. It says that it is before an adjudication of guilt. This is what the actual law says here, that upon a guilty verdict or plea of guilt and before an adjudication of guilt, the judge, without entering a judgment of guilt and with the consent, may defer the further proceedings. And they may do that, and they deferred it, okay? So none of these people have been convicted of anything. And, arguably, they haven't even, you can say that they entered a guilty plea. I think that's fair, because they did do the guilty plea proceeding. That is true. But they did not become adjudicated guilty, okay? The judge just took that, and they're just holding on to it. And if they fail, then they will be found guilty. But this is the same thing that happens in diversion agreements all around this country. It's like first offense shoplifting. You get a first offense domestic violence charge in many parts of this country. You get a speeding ticket, a traffic ticket. You do something, in exchange for doing something, everything goes away. That's the whole point of the First Offender Act. It's to make people not overly oppressed from the criminal court and the criminal justice system. Now, I think it's an amazing thing that these programs exist, because it does give people an opportunity to get things back on track. But it's amazing that Fani would be offering this to 4 of the most heinous criminals, allegedly, in America. So my point is, all of these people took really incredible deals, like incredible. Like their charges are going away like it was a first offense urinating in public somewhere, okay? It's crazy. And Fani is now 0 0 and 4. So every time you hear this stuff in the media that, this is all doom and gloom for Trump, it could be. Like, they could all flip and all start turning around and, blaming him. That's all true. But at this moment, Fani's case is so weak, she couldn't even leverage criminal prosecutions for 4 of the biggest people involved in the case. We'll see what happens with Rudy and the other people, but I thought Sidney and Jenna, 2 of the 3 there, they were 2 on the top row on this tic-tac-toe board, and both of them are going to end up with no convictions at all, provided they comply with the terms of probation. So we're going to jump into the plea deal here in a quick second. I just wanted to show you what the documents look like. Aiding and abetting, false statements in writing. So Jenna Ellis is the person who is the latest to go through this traffic school plea deal process, and hers is a little bit different because she does give us a statement, which I don't know how necessary it was, but we'll see what the proceeding has. But Fani signed this one. Okay, so she's signing on all of these First Offender Act deals, and here saying that she's going to agree to the following, saying that they made false statements to member of the Georgia Senate, saying that these statements were illegal. You made false statements to the Senate, and those things were illegal. Fani Willis very upset about it, but not that upset about it because the case is going to be dismissed, as we'll see in the proceeding. Now, this was the waiver of the indictment, so they brought a new charge against her for this new crime. And so Jenna Ellis signed off on this, saying that she agrees to waive the indictment by a grand jury. And so without any further ado, let's show exactly how this works. Big Fani's courtroom. We've got the usual faces here. All rise.
947
Now we're on the
State
record.
versus Jenna Ellis. We have the state here present in court today, as well as Miss Ellis and her attorney. And just for the record, sir, if you could identify yourself.
Yes, thank you, Your Honor. I'm Franklin Hogue, law partner and wife, Laura Hogue, and we represent Jenna Ellis.
Good morning, Your Honor.
Good morning, y'all. So collective welcome to the Hogues. And I understand that, again, been requested, schedule an impromptu hearing on a change of plea. Is that correct, Mr. Wade?
It is correct, Judge.
Just got it
And
worked
is
out.
Ms. Young taking the lead on this?
She is.
again?
Judge, indeed.
Ms. Young.
And if all the terms, are there any other terms that we need to go over, or is
Nope.
everything agreed to between the parties?
Everything's agreed to and negotiated, Judge.
Amazing. We've
All right,
already
well, if
done
that's
this
the
3
case,
times.
then we have Ms. Young come back up to a microphone, either at the jury box or in the witness stand, and we can go through the colloquy. Yes,
I
sir.
just want to point out that also Ms. Ellis also has counsel out of state, Mr. Melito. He's present in the courtroom and he wanted to get permission to come and have a seat at council table.
No, certainly. I think we also need you to spell your name for the record, just so we're clear.
Yes, Your Honor. Melito.
Okay, welcome. All right, then
Pretty
let's
simple.
get into it. Mr. Hogue, do you have a preference between the podium or at council's table?
You can just stay here if that's all right with Your Honor.
It sounds fine to me. All right, Ms. Young, whenever you're ready.
Ma'am, Ms. Ellis, can you please raise your right hand? Swear affirm the testimony you're about to give shall be the truth and the whole truth, so help you God.
I do.
And are you the Jenna Lynn Ellis that's named in accusation 23 SC 190514, charged with 1 count of aiding and abetting false statements in writing?
Yes, ma'am.
Is this your true and correct legal name?
Yes.
Are you under the influence of any drugs, alcohol, or medication today?
No.
Is there any medication that you should be taking that you have not taken today?
No.
How old are you and how far did you go in school?
38 years old, 39 on November 1st, so very soon. And I completed my Juris Doctor degree.
And are you able to read, write, and understand the English language?
Yes,
Have you gone over this accusation with your attorneys, Mr. and Mrs. Hogue?
I have.
Do you understand that you're charged with 1 count of aiding and abetting false statements in writing?
Yes,
Have you gone over the minimum and maximum sentence with your attorneys?
I have.
And do you understand that that carries a minimum penalty of 1 year to a maximum penalty of 5 years to serve?
Yes,
Do you understand that you have the right to plead guilty or not guilty to this charge? And if you plead not guilty, you have the right to remain silent and move forward with the jury trial.
yes,
Have you reviewed the waiver of rights with your attorneys?
I have.
And have you gone over that waiver of rights and also signed it along with your attorneys?
I have.
Have you had enough time to speak with your attorneys in regards to the facts in this case and any defenses that you may have if you were to have gone to trial?
Yes.
Do you need any more time to speak with them?
No.
And are you satisfied with their services?
Very much.
Heck
Mr.
yeah.
Hogue, do you waive formal reading of the accusation against your client?
We do.
Ms. Ellis, have you been arrested on these charges?
Yes.
And does the state's understand that there are no other outstanding related warrants to this charge? Do you know of any to your knowledge?
I do not.
Do you understand that this is a negotiated plea, which means the state and your attorneys have reached a recommendation to make to the court?
Yes.
Do you understand that the court is not bound by that recommendation and could sentence you to the maximum penalty for this charge?
Yes.
Do you understand if the court does not follow the state's recommendation, then you can withdraw your guilty plea and move forward with the jury trial?
Yes.
Do you understand that the conditions of this plea involves 5 years of probation, that you pay $5,000 of restitution to the Georgia Secretary of State within 30 days? And it's in my understanding that you're asking to be treated as a first offender.
Oh,
Yes.
Do you understand that a special conditions of this probation is that you complete 100 hours of community service,
okay.
that you write an apology letter to the citizens of the state of Georgia, which you have already done, and the state will put that into evidence as State's Exhibit 1 for the court, that you testify truthfully at all hearings or trials
Had to do
involving
that anyways.
co-defendants, that you have no communication with co-defendants, witnesses, or the media until all cases have been closed,
Yes.
that you must continue to provide additional recorded statements and affidavits to the state as required, that you must also continue to provide any requested documents or evidence subject to any lawful privileges asserted in good faith, that you shall not post anything on social media, including through any agents, about this case until the conclusion of all trials and appeals.
That's what they want, okay? They want you to not speak out about it. So we'll speak out about this. And listen, I know that there's a lot of trepidation out there. There's a lot of people who might watch, Jenna plead guilty or watch Sidney plead guilty and feel like it's a loss or something. And I totally understand that. But you have to think about the bigger context of this, right? These charges are going away, and they are going to legally be able to say that they were exonerated under Georgia law. So you got to ask yourself, right? Is it worth just saying, I made a mistake of law, I made a mistake of fact, I'm a victim of political prosecution, so I'm just going to sit here in this illegitimate courtroom, I'll go through these motions, and your life will literally get back on track, right? I know there's a contingent and a percentage of the population that would not ever do that, right? Never admit to something like this. But I think for most people, this is such a good deal that you'd have to be kind of insane not to take it, because we know that in these political prosecutions, things can go the other way, and you can end up like the Proud Boys or the Oath Keepers, victims of political prosecutions that are going to be locked away for decades, presumably, unless Trump wins and pardons them all. But my point is, and shout out to those guys, right? Those guys are heroes who stood up for the right to a trial in a corrupt jurisdiction. And this is very much the same thing, but this deal is just so good. I mean, you'd have to be almost just make a point in not accepting this. And I am also of the mindset that you can accept a plea deal, and that doesn't necessarily mean that you're going to turn on the bigger fish. Now, we'll see. Jenna's going to make a statement here that I've not listened to yet, but we're going to hear what she has to say.
That you must continue to fully cooperate with prosecutors, included but not limited to participating in interviews with prosecutors, appearing for evidentiary hearings, and assisting in pretrial matters. Do you?
Okay, so quick pause on this, by the way. Thank you for sharing this content. Okay, thank you for helping us spread this idea that these are not guilty plea judgments, because they're not. They are deferred adjudications. As we saw, the judge is not even accepting a guilty judgment at this moment. He's deferring it for a later date. So these defendants can't talk about this. Like, they can't defend themselves. They can't expose all of this. They're limited from communicating even the truth about their own deals. So you're going to see in the headlines, Jenna Ellis pleads guilty and she's going to turn on Trump and all those things. She might. I don't know. She might. But that's not what this hearing was. Okay. This hearing was a deferred adjudication, and her charges are going to be dismissed. So
You understand that these are the conditions of recommendation that the state is making to the court.
I do.
It is my understanding that, have you gone over the first offender status with your attorneys?
I have.
And you're asking this court to be treated as a first offender.
Yes, ma'am.
Have you pled guilty or nolo to ever in this state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
And you've gone over the First Offender Act with your attorneys, and do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for this charge and the accusation?
I understand.
Do you understand that this guilty plea may be used to enhance sentencing of any other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that you are being placed on probation and you cannot violate your probation by committing any other crimes in any governmental unit or violate any special conditions of your probation?
Yes.
Do you understand that if you violate the probation or any special conditions, that you will be subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use any firearms while you're on probation?
She's got the firearm question just like Sidney had.
Yes.
Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation?
I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be if you were found guilty at trial? For example, your guilty plea may affect your right to vote, your right to hold office, your right to serve as a juror, the right to obtain a passport, the right to receive, possess, or transport a firearm, the ability to obtain employment, or your membership for the bar in this state or any other states.
I understand.
Do you understand that you are waiving all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a jury trial, the right to remain silent and not incriminate yourself, the right to confront witnesses, the right of the assistance of counsel hired by you or appointed by the court, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel production of evidence, the right to have the charges against you proven guilty beyond a reasonable doubt, and the right to appeal if convicted of these charges.
Yes.
Okay, so I have gone through this process probably over 100 times, and I'm not even joking with you on this, because in Arizona, we have something very similar to this for, well, it depends on the court, but for all sorts of different crimes. One of them is for criminal speeding, and you have deferred adjudication, but the way that we did it in Scottsdale, in Arizona, is you pled guilty first. You go in, you do the guilty plea, but the judge holds off on entering the plea or on sentencing you. Okay, so the equation that I would give to clients is we want to avoid a conviction, okay? That is 1 + 1 = a conviction. We need two things. We need a guilty plea, we need a sentence, and then we'll have a conviction. But what's going to happen here is we're going to enter a guilty plea. We're going to go through the guilty plea proceeding, okay? So we're going to record it on the record. You're going to say that you're guilty. You're going to give up all your rights and all of the things, but the judge is just going to bottle that up and just put it on the shelf. And then once that period of time goes by, you are not going to be sentenced, okay? So 1 + 0 = no conviction. So we're just going to have this kind of temporary guilty plea, but eventually, once we fast forward through a couple months and you do your driving school class and you get your criminal ticket dismissed, we're going to take that guilty plea and just put it right in the shredder, and you're not going to have any conviction. It's literally the same process. Now, again, we didn't have allegedly criminal insurrectionists who were trying to steal American elections at my law firm at the time. They don't have them here either, evidently, which is why they're giving them this diversion deal. It's a deferred adjudication deal. But at this moment, I've done this many, many times, and even though I've explained it to my clients many times, at this moment in these proceedings, people are freaking out in their chairs. Okay. Now, Jenna's not, because she's a lawyer and I'm sure she gets it, but people are still freaking out because as we're listening, it sounds like we're going through a guilty plea, right? Because we actually are. We're going through the proceeding, but it's not going to go anywhere. We're just recording it for the future case in case we need it. But then they're going to say, how do you plead? And guilty. And that doesn't mean that she's entered a judgment of anything because the judge is going to defer it. Listen.
Has anyone forced, threatened, promised, or coerced you in any way to enter into this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
It is.
How do you plead to aiding and abetting false statements in writings and under accusation 23 SC 190514?
Guilty.
And is this your signature along with Mr. Hoag's signature on the accusation?
It is.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you may have only limited rights to appeal this guilty plea?
I do.
And do you understand that you would have 4 years from today's date to file habeas corpus as in regards to this guilty plea?
Yes.
You're under the state, the accusation is signed guilty plea to enter.
Good question came up about her firearms. Now, she is agreeing to give up her firearms. She is not a convicted felon, which is causing her to give up her firearms. As part of the plea deal, they're just negotiating that away. They're saying, we're going to kind of give you some of the penalties of being a felon, but you're not obviously a felon.
According to the state's investigation, Ms. Ellis does not have any criminal history, so she would be eligible for first offender, which the state has no objection
She's
to.
eligible.
All right,
Great.
before we get into a colloquy, I'd ask Mr. Hoag, if you could take back up the waiver form. There's actually a spot on here to circle critical about first offender status?
If this case had gone to trial, the state would have shown the following. On December 3rd of 2020, the defendant did appear before a meeting of a Georgia Senate Judiciary Subcommittee in Fulton County, Georgia, with co-defendants William Rudolph Lewis Giuliani,
Wow.
Ray Sterling Smith III, and other individuals associated with Donald J. Trump for President Incorporated, also known as the Trump campaign. During the subcommittee meeting, Giuliani and Smith, acting as attorneys for the Trump campaign, made the following false statements. One, that at least 96,600 mail-in ballots were counted in the November 3rd, 2020 presidential election in Georgia, despite there being no record of those ballots having been returned to a county election office. Two, that 2,506 felons voted illegally in the November 3rd, 2020 presidential election in Georgia. Three, that 66,248 underage people illegally registered to vote before their 17th birthday prior to the November 3rd, 2020 presidential election in Georgia. Four, that at least 2,423 people voted in the November 3rd, 2020 presidential election in Georgia who were not listed as registered to vote. Five, that 1,043 people voted in the November 3rd, 2020 presidential election in Georgia who had illegally registered to vote using a post office box.
Okay, I want to pause on this very briefly because we caught something that she said in there that I may have skipped over. But this is what she's reading from, okay, this set of documents. And here is what she said. So just to be clear about this, so Jenna Ellis is not being charged with those things. She's with all the things she's reading, okay, that this. She's being charged actually, which is kind of a lesser crime generally, with aiding and abetting Rudy and Ray. And then they went and they knowingly, willfully, unlawfully did the things. So if Rudy, right, so, you know, like if we're playing devil's advocate here and they're saying, well, they're just using all of these people to get someone else. Like Rudy, they better put him in prison for how long? He aided and abetted Rudy, right? So let's see what they get on Rudy. But this is everything that she's reading and it's from the same new information. So this was the new document that they filed. This is not the old indictment, which had the other 19 co-defendants. That's what she's reading from.
Six, that 10,315 more dead people voted in the November 3rd, 2020 presidential election in Georgia. And seven, that Fulton County election workers at State Farm Arena ordered a poll watcher and members of the media to leave the tabulation area on the night of November 3rd, 2020, and continue to operate after ordering everyone to leave. The false statements were within the jurisdiction of the Georgia Secretary of State and the Georgia Bureau of Investigations, who were each conducting investigations into allegations of fraud in the November 3rd, 2020 presidential election in Georgia. Once completed, these and others investigations affirmatively determined that there was no widespread fraud that could have affected the outcome of the 2020 presidential election in Georgia. The false statements were made with reckless disregard of the truth and with conspicuous purpose to avoid learning the truth. The defendant attended and abated Giuliani Smith in making these false statements by assisting with the execution of the December 3rd, 2020 Senate Judiciary Committee meeting that was held in Fulton County, Georgia. The false statements were used as part of a plan by the Trump campaign to solicit the Georgia General Assembly to disregard the certified results of the presidential election in this state and instead to unlawfully appoint non-elected presidential electors in violation of their oaths to the Georgia Constitution and to the United States Constitution. Similarly, false statements and solicitations were made to state legislators in Arizona, Michigan, and Pennsylvania, and the defendant was present and assisted with the execution of those meetings. And she was in attendance with Giuliani in Arizona and Michigan and Pennsylvania. That would be the factual basis in which the state would have proceeded on, Your Honor.
Okay, we got to be careful on this too, because if Jenna, okay, let's say that she turns on Trump and she shows up to testify against him and she starts just running her mouth about Arizona and Michigan and all these other places, she could be charged there and for those crimes, and she could be charged federally, okay? So she's got exposure on that, and this deferred prosecution deal that is going to result in no conviction or guilty judgment doesn't grant immunity to the feds or to the other states. So they also have their self-interest at heart here to not just start testifying lest they be charged again.
All right, anything further from the state, Ms. Young?
Just that we filed a motion of null pros in prison under the original indictment.
All right, turning to Mr. Hogue, just a few matters of housekeeping before I let you have the floor. If there's anything else you want to add, would you be requesting automatic sealing on this first offender disposition?
Of course.
Yes, that's one of my two notes here.
And the other one's crime of moral turpitude.
Under 42-862-1B.
Yep.
please.
All right, and was part of this negotiated resolution, is there anything to note here about a behavioral incentive date?
Yes, Your Honor, that's going to be 3 years.
Mr. Hogue, is that right?
So all this can go away in 3 years, not 5.
That's correct, Your Honor.
And moral
Okay.
turpitude. Don't
Anything
forget.
else, Mr. Hogue, that you would like to add? time.
Moral turpitude.
Yes, if you could make a note that this is not a crime of moral turpitude,
Ah.
that assist us in other venues perhaps.
And is that an issue of negotiation between the parties? I know that has differed from the resolution here. So where are we with that?
It is not, Judge. We're going to ask that the same verbiage that has been put on the other dispositions
Of
be
course.
put on this disposition as well,
Ah.
which I believe it says like the defense and the state have agreed that this is not a crime of moral turpitude.
Amazing.
Okay.
Get that language to Ms. Bordas.
So it's not even a crime of
So
dishonesty.
just to clarify,
either.
it's not a point of contention between the parties. It's being jointly recommended, this language?
No, it's stipulated. They
And is
agree.
that the case for, because I think we needed to enter amended sentences on prior resolutions reflecting that. Is that the same for all three prior resolutions in this case?
That is correct, Your Honor.
Okay. All right. Then if that is the joint recommendation, that'll be part of the global recommendation. Understood, Mr. Hope.
Global
Yeah,
recommendation.
the only other thing is if the court is inclined to accept the negotiated plea, Ms. Ellis would like to exercise her right of allocution and make a brief statement.
All right. So I think I would typically have that as part of the record before we finalize everything. So at this point, Ms. Ellis, you're not required to do so in any way.
That's what
But
it's
if you
not.
would like to add anything to the record or address the court, you're certainly able to do so. And now would be the appropriate time.
Okay, so the judge confirmed, okay, she is not required to do this. And we've listened to 3 other change of deferred adjudication proceedings here. One for Scott Hall. Actually, we didn't listen to that one here, but I did listen to it. And the other 2 that we did listen to here, Sidney Powell and Kenneth Chesebro, they didn't make any statements, okay? They just sat there with their hands in their pockets and they just let the whole thing go. Now, I would absolutely believe that Jenna Ellis didn't have to do this and the same thing would have happened. But she might feel nervous, like the judge might not accept this deal or something like that. Obviously, I don't think that's the case. So I don't know that this was necessary at all. Let's listen to see what she says.
Now, if I may approach, I have it in writing what she's about to say.
I have one attached to State's Exhibit 1. Is that the same?
Oh, yeah, you have it already.
Okay. And so would there be, the intention be that this also be going into the record as State's Exhibit 1, the written form? Okay. All right. Thank you, Mr. Hope.
Thank you, Your Honor, for the opportunity to address the court. As an attorney who is also a Christian, I take my responsibilities as a lawyer very seriously, and I endeavor to be a person of sound moral and ethical character in all of my dealings. In the wake of the 2020 presidential election, I believed that challenging the results on behalf of President Trump should be pursued in a just and legal way. I endeavored to represent my client to the best of my ability. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were in fact true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, I failed to do my due diligence. I believe in and I value election integrity. If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges.
Why?
I look back on this whole experience with deep remorse. For those failures of mine, Your Honor, I have taken responsibility already before the Colorado bar who censured me, and I now take responsibility before this court and apologize to the people of Georgia. Thank you.
All right. So listen, criminal proceedings are extremely stressful and extremely taxing. And I don't want to try to jump inside her mind. I always like to try to give people grace in these positions, of course, because it's really impossible to be in a position like this, right? It really is. And I've represented hundreds, thousands of people in criminal cases, and it is an impossible position to be in. So emotions are high. I certainly understand that. And we can pause and just make that note briefly. Simultaneously, I also don't think that that statement was necessary. I don't think she needed to read that. And so I don't know if that was intended to do something or not, right? I can't predict that either. But that statement was not necessary, in my opinion, legally. Like, you did not need to say that. That being said, it was a pretty traditional sentencing type of statement. I'm sorry, I didn't know. She was kind of deferring some responsibility in that. I actually don't think that that statement is that great, honestly. Like, if you're going to be there accepting responsibility in front of the court, what do is you accept responsibility. You don't say, I was just some dumb lawyer who was following more experienced attorneys out there. You just, look, I made a mistake. I made bad errors in judgment. Thank you, Your Honor. Next question. Or, I'm done with my statement. But she was making some things there that maybe you can infer are going after Powell a little bit or Giuliani a little bit. But I'm also trying to glean from this. Did she say anything in there that specifically targets Trump? That said that Trump ordered me to do something criminal? No. She said, I like election integrity. integrity. I was trying my best. She did say that I wouldn't work for Trump again, or I wouldn't do this again. But I think a lot of people would say that, and probably not because of the criminality that they were involved in, but because they've been prosecuted. I mean, there are tons of lawyers that would not touch Trump or his campaign with a 10-foot pole because of that, because they don't want to come under scrutiny from partisan hacks like Fani. So there's a lot here. Ultimately, I think this was unnecessary and honestly an error. It doesn't have much consequence to it, but we saw Sidney Powell didn't make a statement. She just sat there and the judge just let it go through. Same thing with Chesebro. He didn't say anything either. Okay, so it was unnecessary, which leads me to believe maybe there was more to the story. Maybe she wanted to make a point. Let's finish up.
And thank you, Ms. Ellis, for sharing that all too often.
Yeah.
I don't get to hear the perspective of the accused in this case, in these cases, and so that's appreciated.
Thank you,
Yeah, because most people don't make statements during that time.
Your Honor.
Is there anything else, Mr. Hogue, that you would like to have as part of the record? Ms.
Okay.
Ellis, I have a few questions that I have to go over with you. Do you understand the nature of this charge that as it's been reaccused against you?
I do.
And you heard the rights that you would waive by going forward with this plea. Do you still wish to waive those rights?
Yes.
And are you pleading guilty today because you agree that there is a factual basis as outlined by the state to support this guilty plea?
I do.
Mr. Hogue, are you satisfied your client is competent and that this plea is understanding, voluntary, and that there is a sufficient factual basis to support it? Ms. Ellis, do you have a weapons carry license of any kind in this state or any other?
I do not.
Well, I find that there is a sufficient factual basis for the charges, and I find that this plea of guilty is knowingly, voluntarily, and intelligently entered. Ms. Ellis, you've asked to be sentenced under the First Offender Act,
Boom.
which is a request that I will approve, and I'll
Boom.
withhold adjudication. But I do
Boom.
have to notify you that
Did you hear that little phrase? Now they fast forward over this because they don't want to be articulate about this, but I will accept and enter your plea, but I will withhold adjudication, meaning it's not going to get entered on the record, okay? It's going to be held in abeyance. Listen.
Ms. Ellis, you've asked to be sentenced under the First Offender Act, which is a request that I will approve, and I'll withhold adjudication.
Ooh!
But I do have to notify you that you can't withdraw your plea simply because you don't abide by the terms of the sentence. And the terms of the sentence would be as negotiated and agreed to by both parties. On the sole count of aiding and abetting false statements and writings, the sentence would be 5 years probation. You're to pay a $5,000 fine to the Georgia Secretary of State's office within 30 days of the entry of the final disposition in this case. You're to complete 100 hours of community service. You are to cooperate with the state and testify truthfully in any further legal proceedings in this
Already
case.
going to do that anyways.
And you're not to have any contact, either personally or through other agents, with the media or any co-defendants or witnesses, I believe, in this case, as was outlined.
Yeah, that's because Jenna Ellis has a pretty big following out there, and they would hate it if she came out and told everybody that these are deferred adjudication plea proceedings. These are not guilty plea being entered as judgments at all.
We will include the language that is sent to us subsequently from Ms. Young, of course, with Mr. Hogue attached on that email to make sure that it is the exact language as agreed to by both parties. As requested by counsel, as a first offender sentence, this would be automatically sealed upon entry, and there'll be a behavioral incentive date of 3 years as well.
Automatically
I've
sealed.
been
Not
provided
bad.
a motion to null pros the counts on the underlying indictment in 23 SC 188947, and I'm signing that now.
Sign it, Judge.
Is there anything else from the state that you believe we need to have on the record in this case?
No.
Judge, and if I misspoke, I said it should be a $5,000 restitution because the max fine is only $1,000.
Excuse me, that's right.
I may have missed.
No, that was my mistake. So it is a $5,000 restitution. I didn't hear a fine.
There is no fine, Judge.
Okay, understood.
Put it in the wrong box.
Anything
Just
else
put it
I
in the
need
right
to
box.
clarify or may have? Obviously, we will, as I mentioned, go off the language that were provided subsequent to this hearing. Anything else from the state, though? Okay, Mr. Hogue, anything else we should have on the record? Take your time.
It's our understanding there won't be any travel restrictions as a part of her probation. I want to just make that clear for the record that there's no misunderstanding or dispute about that. She lives out of state.
No, understood. This is sometimes a challenge with out-of-state residents that we have to have things transition and be moved to the out-of-state probation office, and they have to accept it as well. And so whatever we can do to facilitate that process, I would like to do. That may mean that if she has a flight today, I don't know if that's going to be possible.
All right, so they're going to the rest of the kinks, the mechanics there, but we get the gist of it. Okay, Jenna Ellis gets a deferred prosecution agreement. She goes through a guilty plea proceeding, but that guilty plea has not been entered as a judgment. And provided she completes her 3 years of probation, will terminate early if she's compliant, which she will be, everything's going to go away. So Fani Willis is 0-4. She keeps losing. It's unbelievable that she would keep giving defendants involved in an American insurrection traffic school plea deals that'll all be be dismissed later on down the road. My friends, we're going to continue to cover this case in depth. Thank you for joining us as we do. Thank you for subscribing. Thank you for inviting somebody to come over here and join us and watch as we uncover and expose the truth about what's happening in these proceedings. And we'll look forward to seeing you on the next one.